have 2 filings from Doug Weinstein, Jay Apt, and Katie Hingerty. So we're going to look at those 2 motions that were first filed on behalf of their client, Deamonte Kendrick. I feel like this is going to be a Super Tuesday of filings coming in. So my schedule is clear. We can go as long as we need to go, and I think it'll be an interesting day. So first we're going to look at a motion for bond. It's the second renewed motion for bond for Deamonte Kendrick. That means they filed this before. They've asked twice already, give our client some bond. And now, because of a change in circumstances, we're asking again. So this is real short. It's barely 3 pages, and then we'll get into the motion for a mistrial. So comes now the defendant in the above styled case, and I can make this bigger. You guys say hey in the comments, hit the like button, do all those things. Comes now the defendant in the above styled case and moves this honorable court to set a reasonable bond pending the disposition of this case, showing the court the following. That to the present date, no bond has been issued for Deamonte Kendrick. That Kendrick is currently being held in the Fulton County Jail for over 2 years, since May 9th, 2022, charged with the following 9 counts. And guys, just so you know, those 9 counts are here. It's the conspiracy to violate the racketeer, the RICO Act, murder, 3 counts of violation of the Georgia Controlled Substances Act, possession of a firearm or knife during the commission of a crime, possession of a machine gun, use of firearm by convicted felon, and then these 4 counts here for unlawful for a person employed by or associated with a street gang to commit a crime. So those are the 9 counts that Deamonte Kendrick is facing, and let's hop back over. So Kendrick was denied bond in 2022 and 2023, the first 2 times we asked, after the state argued that defendant and his co-defendants were a danger to the community. Since the denial of bond in 2023, the state has presented its case in a plodding manner. Plodding means it's dragging. It's boring. It's like just moving sluggishly. With no apparent concern that Kendrick and his co-defendants at trial are incarcerated, presenting witness lists that have times topped 700 witnesses. So remember, Judge Whitaker said, you need to give me an updated list because we're not going to do that cumulative witness thing. We're not going to do it. To date, the state has presented almost 100 witnesses with no end in sight. While the state has argued that Kendrick is a threat to the community, none of the state's 100 witnesses have presented any testimony demonstrating that threat. The state has had 7 months to do so and failed. Now, last week you may have heard me be a little bit critical of the motion for bond filed on behalf of Marquavius Huey, or Quay, by Careton Matthews. Careton Matthews lays out, look, there's been a change in the circumstances of the trial. The trial's dragging on, so I'm requesting bond again. But I felt like it was missing a little bit of details and a little bit of argument for this, why my client in particular should get a bond. Here on page 1, we're already seeing, look, we're 100 days in, 100 witnesses in, and there's no testimony that my client is a danger to the community, which is what the state would argue a bond is not deserved, a bond is not warranted, a bond should be denied. So a pretty good argument to include that I think was kind of absent in the other motion. Since the denial of bond, the state has offered and entered into plea agreements with at least defendants Murphy, Arnold, Stevens, Greer, Kitchens, Sledge, and Lee, permitting them to return to the community. This offer was despite having previously argued to this honorable court that those defendants pose a threat to the community. So the argument is wishy-washy. The court, having been convinced by the state's arguments before, should no longer provide the state with the benefit of the doubt. One must now question how much of a threat the state truly believes these defendants pose. Therefore, any arguments made by the state in opposition to this motion ring hollow. Now, is it Rodalius that the only count he faces is the RICO count? Because I wonder if we're going to see a motion for bond for that person that's only facing the 1 RICO count. Because it's like, if all these other people that we just named, they successfully argued that we're not a danger to the community, but we still have someone on trial as an enjoined co-defendant with Young Thug and Deamonte Kendrick, that their only count is the RICO charge. No other specific acts are charged to this defendant. I hope we get a bond motion for that person, because that's crazy to think about. One must now question how much of a threat these defendants truly pose. Therefore, any arguments made by the state in opposition to this motion ring hollow. Argument 7. The court has granted bond to defendant Miles Farley following his severance from the present trial. Now, Miles Farley was the one whose attorney was arrested for allegedly trying to bring prescription pills into the courtroom. 8. That Kendrick poses no significant risk of fleeing from the jurisdiction of this court or failing to appear in court when required, and is not an extraordinary bail risk. 9. That Kendrick poses no significant threat or danger to any person, to the community, or any property in the community, and will not jeopardize the safety of the community if admitted to bail in this case. And 10. That Kendrick poses no significant risk of committing any crime pending trial. 11. That Kendrick poses no risk of intimidating witnesses or otherwise obstructing the administration of justice. Can you imagine trying to intimidate 700 witnesses? Or telling someone that they're a threat, they're intimidating witnesses? Well, which one? All of them? It's crazy to think about in the context of this case. Kendrick assures this court that, if admitted to bail, he will neither flee nor go into hiding, but will respond to each and all orders of this court as directed. 13. A reasonable bond, by definition, is one which is adequate to assure the principal accused will return to face the judgment of the court, but at the same time, one which is attainable by the defendant. In this case, the court's failure to set a reasonable bond for Kendrick has kept him incarcerated since the date of his arrest. 14. If Kendrick were granted a reasonable bond, and through a surety authorized by the state of Georgia, he could return to his employment and aid counsel in preparing his defense to the charges in this case. And then they make an attachment for the rule. And then this was actually written, it's cut off here, but it was written by Weinstein, Katie Hingerty, and Jay Apt. All three of them penned it. So there's that. There's the motion for the bond, and we're going to get into what I'm assuming you guys will find meatier. A bit more juice and tea behind it. Motion for mistrial. And we've heard Doug Weinstein say on Friday on Nick Starrow's show, and also I think on the podcast, that he was going to turn this in on Tuesday, so here it is. It is 15 pages, including the signature pages. So, and yeah, if you forgot to hit the like button, hit that, because I don't know if you guys all have the updated interface, but YouTube changed its interface. It's kind of a little annoying to click out of the chat, find the like button. So the likes are kind of going down, and it's free. So if you guys want to take 1 second, hit that like button, I'd appreciate it. And then I also want to thank Taybiz TV. Taybiz TV did great coverage of the status hearing on Friday. So make sure you check out Taybiz TV if you didn't see that, or if you just want to watch it again. Thank you for the super chat. Q became a member. Q, I thought you were a member. Well, thank you for becoming one. I think I'm picturing you in green on other channels when I see you in the chats over there. And then shout out to No Weapon Formed Against Me for also becoming a member. And then as always, thank you to Drea for doing great work as the mod in this channel. Maybe that just means return to employment in general, but I don't know. I don't know where Deamonte Kendrick worked before this. And then let's see. We have, comes now Deamonte Kendrick by and through his undersigned counsels, and brings this motion for mistrial showing as follows. We think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a jury from giving any verdict, whenever in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act. Now this is important because this is where we're going to get the retrial debate. Or the ends of public justice would otherwise be defeated. They are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances which would render it proper to interfere. But after all, they have the right to order the discharge and the security which the public have for the faithful, sound, and conscientious exercise of this discretion rests, in this as in other cases, upon the responsibility of the judges under their oaths of office. And that's from Jones v. State. The state has had witness after witness fail to provide the testimony that it would like the jury to hear. Rarely in the recent history of Fulton County Superior Court has one party had to impeach so many of its own witnesses, including at least the following key witnesses. Trontavia Stevens, Walter Murphy. Guys, these are people that were given plea deals, and yet they've had to be impeached. So Trontavia Stevens, Walter Murphy, Arkelian Bennett, Eduardo Nava Flores, Adrian Bean, D'Angelo White, and critically, Kenneth Copeland. What is the state going to do? Losing its case, apparently unconcerned about the need for public justice, the state clearly sought an opportunity to restart the trial by triggering an event in such egregious violation of the constitutional rights of Kendrick. Guys, this is huge. What's being argued here? They're going to say that the state, Adrian Love, goaded us into filing this. And if they're goading us, if it's the prosecution goading us into a mistrial, then retrial should be barred. This mistrial should be granted with prejudice. This is a big argument. This is a big argument. No wonder Doug Weinstein's always kind of like giddy and kind in his demeanor. So I didn't really know what to make of it, but he seemed extra giddy when he said he was filing this. You're going to see. He is making the big argument here. Kendrick has no choice but to request a mistrial because the state, according to this motion, wanted a chance, a second turn at running their argument, running this trial, and doing it better a second time. So now, goaded by the state and the actions of Chief Judge Glanville, Kendrick has no option but to move this court for a mistrial to respect the constitutional rights of Kendrick and not defeat the ends of public justice. While this trial has been riddled with scores of errors, at least 3 demand an immediate mistrial. First, placed in an impossible position by the state, this court is faced with the task and requirement to reset this case to at least the point, the afternoon of June 12, 2024, when Kendrick moved Judge Glanville to recuse himself, and he improperly failed to hold all proceedings pending determination of recusal. Since that date, the jury heard days of testimony from Mr. Kenneth Copeland, testimony that can't be unheard. Second, Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings, the secret ex parte meeting among the state, Chief Judge Glanville, Copeland, state investigators, court staff, and deputies. Third, Kendrick's due process rights were violated when Chief Judge Glanville wrongly coerced Copeland to testify. None of the above 3 reasons for mistrial would exist absent of the state's intention to goad Kendrick into the unfortunate position of having to regretfully request a mistrial. We don't want a mistrial. We think we're doing good. We think our defendants, at least my client, has a good chance of a jury acquittal because the state has ran their case as such a mess. 100 witnesses in, having to impeach several of their own witnesses. This is great writing. And I remember Doug Weinstein shouted out Katie Hingerty for really being like the kind of writer of their team. So if this is her, like, big props to her. We need to get her picture to put it on a thumbnail. But like, think about the argument that's being made here. We don't want to request this mistrial. We want the jury to be able to decide. But it's so bad that we have to. They're goading us into doing it. And because we thought we have a good shot with this jury, you shouldn't be able to retry us and let the state try it twice. So what's the background here, you guys? In January 2023, or nearly 18 months ago, trial began in Fulton County Superior Court. Now remember, trial starts when jury selection begins. So jury selection took more than 10 months with trial before the selected jury began, before they were sat in November of 2023. A secret ex parte proceeding was held on June 10th, 2024. In attendance were Judge Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, court staff, and members of the Fulton County Sheriff's Office. A central figure, perhaps the central figure, in the state's case against Kendrick and the other defendants is Mr. Kenneth Copeland. On Friday, June 7th, 2024, Copeland was sworn in, after being given a grant of immunity and being warned by Glanville that incarceration may be the result if he refuses to testify. Copeland continued to plead the Fifth. Copeland was held in contempt and ordered incarcerated by Chief Judge Glanville on that date. Chief Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th at 8:30 a.m., where Copeland would announce whether or not he was prepared to testify. Defense counsel were told to be present in court at that time and were in fact present. Unknown to any member of defense counsel, an ex parte proceeding was held in Chief Judge Glanville's chambers on that date. Among the attendees were Glanville, Love, Hilton, the Fulton County investigators, deputies, sworn-in witness Copeland, court staff, and Copeland's attorney, Miss Kayla Bumpus. No member of the defense counsel was present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights and the meeting being held during a critical stage of the trial. Neither Chief Judge Glanville, any member of court staff, nor the Fulton County DA's office made any member of defense counsel aware. So what do we have here? It wasn't anyone, none of the investigators did it, right? So that's a little bit of a new clarification, right? We've been speculating. We figured it wasn't Glanville. We figured it wasn't the state, obviously. But it wasn't a member of the court staff, nor the Fulton County DA's office. None of these people made any member of defense counsel aware of the ex parte proceeding, either before, during, or after the proceeding. Several defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland, though not from Judge Glanville nor the DA's office. Critically, Brady material was disclosed in the ex parte proceeding and withheld from the defense counsel. This is a big issue that just passed in the Baldwin trial, the Alec Baldwin trial. A review of the recently released transcript of the ex parte proceeding reveals the occurrence of the following events. So, this might seem repetitive, but it's going to be interesting to see if the same things are being argued as the first time we saw an affidavit. So Copeland announced that he would invoke his Fifth Amendment right and not testify. Copeland stated that he would rather sit in jail for 2 years than testify. Chief Judge Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated longer than that, until additional defendants were tried, not just the 6 on trial right now. Copeland was informed that there were over a dozen defendants left to try. Following the above coercive actions by Chief Judge Glanville, working in concert with the state. Remember, they're on the same team. That's been, the defense is acting as a team, calling them a team. So, in concert with the state, sworn witness Copeland stated at the ex parte proceeding that he would testify. Chief Judge Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. Copeland stated that he would lie on the stand. So those are the final bullet points there. The state never gave Kendrick these critical Brady materials. These troubling facts not only implicate Chief Judge Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Following the secret ex parte proceeding on June 10, 2024, petitioner filed and presented a motion to recuse and accompanying affidavit. So that's the original affidavit we saw with the extra points that we didn't see repeated here. To Chief Judge Glanville on June 12, 2024. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and violations of the Judicial Code of Conduct that occurred in the meeting. The motion was summarily denied, with a formal order issued on June 14, 2024. Despite meeting all requirements of Uniform Superior Court Rule 25, guys, and this is important to lay out, because what's happening here is, this is the block of time that, because this June 12th thing was granted, although it was granted later, the trial still was going on. We had more testimony from Copeland, and we continued to have hearings and rulings. But we went back. Judge Krause ended up going back and granting the June 12th motion to recuse Judge Glanville. So now, how do we correct this gap of time? So we have to lay these dates out again. We've heard them all. We're pretty familiar with them, but we have to lay them out because we have to make this argument to Judge Whitaker. So despite meeting all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedure of USCR 25-3. A formal order denying the motion was entered on June 14, 2024, just 2 days after the motion for recusal was filed. On July 1st, so quite a ways ahead, Chief Judge Glanville reversed his order of June 14th and referred Kendrick's motion to recuse to another judge to determine the merits of Kendrick's recusal motion. On July 15th, Judge Krause recused Chief Judge Glanville. So here's the argument. Mistrial is required as all proceedings after June 12, 2024 are void. It is currently July 23rd. Let's think about that. This honorable court is now faced with the unenviable, we don't want to be you, and impossible task of rewinding the case to the afternoon of June 12, 2024. If a party files the motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and of no effect. Kendrick moved Chief Judge Glanville to recuse during the afternoon of June 12th. He denied that motion. Critically, Chief Judge Glanville failed to follow USCR 25-3 by not halting proceedings and sending the recusal motion to another judge to rule in the recusal. So this is no fault of the defendants. That's what's being argued here. It wasn't us that made the trial keep going. We didn't make that error. It was not the fault of the defendants. This was a rule. This was something that should have been followed by the court, and it wasn't. Subsequently, Judge Krause, on July 15, 2024, found that Chief Judge Glanville should have been disqualified. Therefore, under Probst, I always say that wrong, all proceedings since June 12th are invalid and have no effect. This honorable court is now saddled. And if you watch how this is being presented, you didn't put yourself here, Whitaker. You inherited this problem. We know you're in a tough position. We don't envy you for that. But you have no choice. You have this impossible task. There's nothing you can do. This language is it's a call to action, but it's a call to action that's placing no fault on Whitaker and no criticism or pressure on Whitaker. The pressure's being put on the situation and surrounding the situation that was packaged up and dropped on her table. So this honorable court is now saddled with the repercussions of Chief Judge Glanville's failure to follow Rule 25. He should have halted all proceedings as required under Rule 25 and referred Kendrick's motion to recuse for assignment to another judge. Nevertheless, he persisted. Under repeated objections from Kendrick and other counsel, the tainted testimony of Copeland was presented to the jury over the course of 4 days. The remainder of the day on June 12th and June 13th, June 14th, and June 17th. During that time, Chief Judge Glanville, who should have been disqualified, repeatedly ruled against Kendrick and other defendants on multiple objections regarding the questioning of Copeland. Now, this court is tasked with unringing the bell. Now, if you've watched literally one trial in your life, you've probably heard that phrase. You can't unring the bell. You can't put the toothpaste back in the tube. You can't uncluck a fluster cluck. These phrases. There's no choice. There's nothing else that you can do besides call it a mistrial. And because it was goaded by the state and kind of by the judge, should be a mistrial with prejudice. But they're writing this in a very courteous and kind of forthright, empathetic way to Whitaker. How is this court to accomplish this impossible task? How does this court take the jurors' notes from these days from the jurors? How can the jury unhear days and days of testimony? This is not a matter of a witness uttering a single statement that a court instructs the jury to disregard. It is neither feasible nor plausible that an instruction to disregard days of testimony can be followed. Instructing someone to not picture flying elephants only results in the listener conjuring images of Dumbo. But that's true, right? It's like, I don't know if you guys have ever heard of The Game, where if you think about the game, you lose the game, and then you gotta announce that you lost the game. So I lost the game right now, thinking about it. Or thinking about breathing, or blinking. The second you're thinking about breathing, now you're aware that you're breathing, and you're like, oh, how am I gonna stop thinking about breathing? So if you tell people, if the jury walks back in whenever they're supposed to come back, right now it might be August 8th, but that might be pushed back further if Judge Whitaker thinks that there's more motions that she needs to go through. They come back on August 8th, let's just say, and they sit down, and they see a new judge sitting up there, and then they're like, hi, I'm a new judge. Don't worry about that. The court's not supposed to take a stance on, the guilt of any of the defendants or anything like that. And also, can you, ignore the last guy that you saw on the stand? Pretend that didn't happen. The one that was making jokes and had the court laughing and, pretty memorable testimony, maybe if not for the testimony itself, but for the back and forth between the witness and the state. Just forget all of that. That thing that you've had in your memory since you've been on a month-long break while we figure this out. Just forget it. That doesn't work. That doesn't work. Given the impossibility of erasing the proceedings since June 12th, 2024, proceedings that are void due to the state knowingly, improperly requesting Chief Judge Glanville to hold an improper ex parte meeting with sworn witness Copeland, and Chief Judge Glanville subsequently failing to hold the proceedings as required, this honorable court has no alternative but to declare mistrial. This motion for mistrial would not exist absent the state requesting the improper ex parte proceeding. Simply put, Kendrick was goaded into requesting this mistrial through the state's intentional effort to put Kendrick into this position. Mistrial is required as the June 12, 2024 secret ex parte meeting was at a critical stage and violated Kendrick's rights. Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings. The secret ex parte meeting among the state, Chief Judge Glanville, Copeland, state investigators, court staff, and deputies. Defendants were not provided notice of the hearing. Under both the federal and state constitutions, a criminal defendant has a right to be present during critical stages of this trial. Allen v. State, defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. A critical stage is one in which a defendant's rights may be lost, defense is waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in other ways. Here, the outcome of this case is substantially affected by the bullying of Copeland into changing his mind regarding testifying. Copeland is the key witness. The key witness, not a. That is the. To the state's allegation that Kendrick was involved in the murder of Donovan Thomas. While the case against Kendrick is weak at best, even with the testimony of Copeland, without Copeland, the state has virtually nothing attaching Kendrick to the murder of Thomas. The ex parte meeting with Copeland was thus a critical stage of the trial in which Kendrick had a right to participate. A mistrial should be ordered by this court, given that Chief Judge Glanville denied Kendrick's constitutional right to be present during a critical stage of the trial. The ex parte meeting with Copeland. Furthermore, the mistrial is a direct result of the state putting into motion the ex parte meeting, knowing that such a meeting would goad Kendrick into moving for mistrial. So now two of these arguments here have been, it was goaded. Kendrick is goaded into filing this. Mistrial is required as Chief Judge Glanville tainted the proceedings by improperly coercing Copeland to testify. Copeland's testimony is tainted by the improper meeting prompted by the state, where Glanville wrongly coerced Copeland to testify. Chief Judge Glanville's coercion of testimony by sworn witness Copeland, in the face of Copeland's repeated refusal to testify and Copeland's statements that he would lie on the stand, was an act of impermissible intimidation and a violation of the Judicial Code of Conduct. Kendrick's constitutional rights to due process and a fair trial have been violated by the above actions, and the state's actions in working with Chief Judge Glanville on the coercion has intentionally goaded Kendrick into the only possible outcome. This motion for a mistrial that should be granted by this court. Oh, there were a lot of footnotes there. There's a lot of footnotes. As a natural result of the state's actions, Chief Judge Glanville has violated multiple rules of the Judicial Code of Conduct, the violation of which deny Kendrick's constitutional rights to due process and a fair trial. As requested by the state, Chief Judge Glanville held an improper ex parte proceeding conducted with sworn witness Copeland. And now this footnote cites Uniform Superior Court Rule 4.1. That's all the rules of ex parte meetings. So it's generally prohibited for an ex parte communication, except as authorized by law or rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte hearings are only authorized in the case of extraordinary matters such as a temporary restraining order and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. And we can see that obviously the defense wasn't able to be present, wasn't able to object, wasn't able to be heard. And in fact, when a defense attorney tried to inquire about it, they were threatened with contempt and then held in contempt of court. So the arguments up at the top here continue. The secret ex parte proceeding with sworn witness Copeland was also a violation of at least Section 2.9 of the Georgia Code of Judicial Conduct. And then 2.9 here, this is where we need fair hearings, and we need to avert ex parte communications because A, judges shall accord to every person who has a legal interest in the proceeding, or that person's lawyer, the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications, or consider other communications made to them outside the presence of the parties, or their lawyers, concerning a pending proceeding or impending matter, subject to the following exceptions. Now this is where we have to ask, did this meeting meet an exception? So where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits. So I think we're already excluded here, but they include the A and B. But this ex parte meeting dealt with substantive matters. But they say there are some exceptions if that's not true and the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communications. What was the state trying to accomplish? They wanted their witness to be able to testify instead of pleading the fifth. So they slapped an immunity, protective immunity deal, use immunity, onto witness Kenneth Copeland. B, the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. Did the judge notify? And did the judge let all parties have an opportunity to respond? So those are the exceptions to point 1. 2 here says judges may obtain the advice of a disinterested expert on the law applicable to a proceeding before the court if they give notice to the parties of the person consulted and the substance of the advice, and afford the parties reasonable opportunity to respond. So, I think the consensus has been, anytime we've looked at these, that the ex parte meeting and the way it was conducted did not fall within the scope, this allowable scope here. And then I do want to stop and take a shout out to Tebow Den 50. Thank you, Kat. You're awesome. There's no way for a fair trial. Free thug. And I was thinking about this morning, was it the YNW Melly? Some other trial just had someone sneak onto, it was NBA Youngboy. They had a hearing yesterday, I think, and someone snuck onto the Zoom call and was like, free NBA Youngboy. And every time I hear free thug, all I think of is the Zoom callers in the Young Thug trial that got in there and just started yelling free thug. Thank you so much for your super chat. And then you guys, as we're going, I saw a comment and it slipped by. So thank you to whoever it was from, but they pointed out that I think it was Lil Rod. He's already serving a life sentence anyway. So bond would kind of be, there's no point because he's got something separate he's dealing with. So thank you for that. I'm sorry I can't see who that came from. And let me correct this too. So there was no court today. Today, the 23rd, is the deadline for the filings for both sides to argue about mistrials and anything else. Tuesday next week, the 30th, at 8:45 a.m. sharp, is when Whitaker plans to hold a hearing for oral arguments on some of these motions. So it will be a Tuesday, but it's next Tuesday, not today. 8:45 a.m. sharp. And then let's see. Oh, and that's another detail. So Lil Rod was actually granted an appeal. So maybe a bond motion would be worth it then. And that's crazy. Like, that's how all the layers add in and become important. Yeah, and you guys are saying, so Dre is saying the same thing. I believe, according to his dad, that Lil Rod was awarded a new trial on that case. So good to know. And that's crazy too, YNW Melly on retrial, but not until September 2025. That's a long time. That's a long time. And then let's see. This is in mid-sentence here. So the secret ex parte proceeding with sworn witness Copeland was also a violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person a fair hearing. Ex parte communications are presumed to have been in error. So that was Pendergrass v. Skelton. And likely prompted by the state, not only did Chief Judge Glanville fail to notify defense counsel about the ex parte proceeding as required, but Chief Judge Glanville made every effort to conceal the proceeding. Chief Judge Glanville shouted should not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify on behalf of the state, either in or out of the presence of the jury. The situation of the present case is analogous to the situation in Webb v. Texas. While in Webb, a trial judge intimidated a defense witness into not testifying, the corollary is presented here where a trial judge, chief judge, and guys, this footnote is continuing this Rule 2.9. I'm not going to read through that because we've read through a lot of this stuff already. But if you guys want, we can go back and read the stuff in full. But it's just, the judge isn't supposed to consider things that aren't already part of the record because they come in through ex parte communications. They're not supposed to go into that stuff. They're not supposed to permit it, initiate it, seek it. They're supposed to avoid it. But if we continue, while in Webb, a trial judge intimidated a defense witness into not testifying. The corollary is present here where a trial judge, Judge Glanville, intimidated a state's witness into testifying. The Supreme Court's language in Webb is instructive. In reversing a conviction, the Supreme Court said that, in light of the great disparity between the posture of the presiding judge and that of a witness in these circumstances, the unnecessarily strong terms used by the judge could well have exerted such duress on the witness's mind as to preclude them from making a free and voluntary choice whether or not to testify. Now, when you give testimony or sworn statement under duress, that's a problem, because it could impact the truth. And I might swear to tell the truth under duress without intending to commit perjury for the sake of perjuring or lying or giving a false statement. But I'm doing it because I feel threatened, because I feel like I have no other choice. So, if someone is under duress, when they agree to give testimony or give a statement, it's not good. So what is Weinstein, Hingerty, and Apt going to argue here? That same disparity occurred with Kenneth Copeland, Lil Woody. A trial judge in his chambers, in cooperation with prosecutors, surrounded by investigators and law enforcement, while he was handcuffed, coerced Copeland with the threat of years of jailing. The state and the judge exerted such duress to preclude Copeland from making a free and voluntary choice whether to testify. Thus, Kendrick, who was neither present nor represented in the ex parte meeting, was deprived of his 14th Amendment due process rights. As in Webb, this court can't repair the infringement of Kendrick's due process rights under the 14th Amendment, regardless of whether the violation was under Webb or Wynne. Kendrick's rights were violated by the judge's intimidation and coercion of Copeland. As the state likely expected, Kendrick has now been goaded into seeking a mistrial because of this due process violation and regretfully requests a mistrial. Wherefore, Kendrick respectfully and regretfully requests this honorable court to declare a mistrial based on the practical impossibility of voiding the case after June 12, 2024, the violation of Kendrick's rights by his being absented at a critical stage of the proceeding with a sworn witness, and or the tainting of the testimony of Copeland by the improper coercion of his testimony by Chief Judge Glanville. Furthermore, Kendrick respectfully requests this honorable court find that his request for mistrial was goaded by the state, because the state requested this ex parte meeting. The state requested Judge Glanville to do that. And Kendrick, he was absent from the meeting. So the state joined with Chief Judge Glanville in the coercion of Copeland. This 23rd day of July, 2024. And there you go. You have Doug Weinstein, Jay Apt, and Katie Hingerty here signing. And I think, there you go. And this is probably, maybe we'll hear the oral arguments for this on the 30th. Which will be cool because we've never really, since the stuff started happening as a result of this ex parte meeting, really the biggest insight, sneak peek into oral arguments was Brian Steele's inquiry and Gachtel, the defense attorneys, Ashley Merchant and Alex Souser, coming into the courtroom and saying, like, hold on, we're going to argue this contempt order. But we haven't really seen that many oral arguments about these motions thus far. But next week, on Tuesday, on the 30th, we might get that. And, okay, so we've got some people saying that Lil Rod's life sentence got overturned, the conviction, and then that the murder charge did not get overturned. So I'm not entirely familiar with that. So I'm just reading what the chat's saying there, just for clarity. But I would imagine if Lil Rod's defense counsel thinks it makes sense to file a renewed motion for bond or a first motion for bond, in this instant case, the case that we're looking at here, they'll be the ones that look at the context and make that decision to do so or not do so. So we'll see. But what do you guys think of this motion for a mistrial? I really like the writing style, personally. You know, there aren't really any personal insults. We do get the nudging that Judge Glanville violated a rule and the state goaded him into doing it. So there was intentional and purposeful wrongdoing by not just the judge, but also the state. And all of that in totality, in 3 different ways, goaded our client into filing this motion for mistrial. And we don't want to do that. And really, they need to argue that they don't want to do that, because the point is, you shouldn't allow a retrial when it was looking like the defense may have been acquitted or won the first round. That would be unfair. We're not asking for a mistrial because we want the second opportunity to have a better shot. We think we have a fair shot now, but this is so egregious. We have no choice because the state has goaded us. So, there's that. And yeah, Tasker, I think that was an argument too, that they mentioned that the Brady material, like nobody came forward and disclosed that to them. Okay, so we're thinking, it seems Max Shart said he was only granted an appeal. Lil Rod won an appeal for a new trial. So, oh my god! Stevie, VJ, Candace! The state is still trying to get their first paragraph to respond. Oh my gosh. I'm not kidding. When they had to ask for the extension and then they were still late to file, all I could think of, tell me if you guys watch SpongeBob or have ever seen a SpongeBob episode, because it was one of the earlier ones and it was a pretty popular one. Let me pull up the picture of what I'm talking about. Well, this is like some crochet art of it. Oh, here it is. Okay. This is what I think of. So SpongeBob had to write an essay about what he learned in boating school, and he's like stuck in the courtroom, he's sweating, he's got a pencil, he's like about to break the pencil, and after like the clock visually is turning for hours, they finally show the page, and the only thing he's done after it looks like he's been writing was artistically write the word "the." So that's all I can think of whenever I think of Adrienne Love, who seems to want to write motions on behalf of the state by herself, has to request an extension to file on time, and then still files late. And then to me, it was a 9-page mess. It was a 9-page mess. And I'm really trying to say that going into it and looking at it and trying to look at the arguments. This is what it reminded me of. SpongeBob trying to write an essay on what he learned in boating school. So, what else do we have here? Let's see. Nothing new filed on, let me see. Let's pull up. Let me sign in to the portal. So you guys don't see me trying to struggle to remember my password, which is a big struggle for me. And then let's look and see if anyone else is new. And I'm assuming, let's just look and make sure that that was the two. I'm pretty sure Doug Weinstein said that these were the two motions that they planned to file. Okay, so that's what we've got for Deamonte Kendrick, those two motions. An EDW Raptor with 5 gifted memberships. You guys, if you got one, or even if you didn't get one, make sure you say thank you to EDW Raptor. Gifts are my favorite feature of YouTube. Well, the chat, and then also gifting. So thank you so much. And it's a joke, you know, now you have a green name, and you get to use the Mario Kart emojis, the member emojis. So click the little emoji sign if you're a member now, and you'll see. You can choose your Mario Kart racer. Let's see. Anything from Brian Steele? Let's look under Jeffrey Williams. I feel like I get arthritis just trying to scroll through all the updates from the start of this case. Like, look how much this is. This is a long scroll bar. Crazy. And those are the 3 that we saw last week. These aren't new. And then anything, let's check if Careton Matthews has filed anything. I mean, a lot of them, you know, this motion for mistrial would apply across the board. So maybe we won't see as many filings from the defense attorneys as, you know, we kind of thought. That was the motion we saw last week, nothing new. It's really a novel. And who else we got? Shannon Stillwell. We'll see if I'm pretty sure Shard said he was filing. Or Shard said he was filing. Nothing from him yet. Oh my god, an EDW Raptor again! Thank you so much. That's so nice of you. Aw. You guys put the little dinosaur emoji in the chat for EDW Raptor. I don't know, is that a Rex emoji, the dinosaur? I think, is there a Brontosaurus emoji? What emoji does YouTube have for a dinosaur? Yeah, and guys, so that's the other thing, nothing from the DA, because if the state had filed something, we would see that attached to, you know, the filings for all of the defendants that are enjoined in this case, any of the 6 defendants. So nothing yet from the state. Put a 1 in the chat if you're not surprised we have nothing from the state. And then let's see, let's look at Rodelius Ryan. I mean, yeah, nothing there either. So that'll be an interesting one to watch if Lil Rod files a motion for bond. If the other case has an appeal pending. Because if he is stuck with a life sentence anyway, it might not make sense to file for bond in another case. But if he's appealing the other sentence, it might make sense to file a motion for bond because say the other thing's appealed and overturned within the next year, right? Just play hypothetical with me. Even if Whitaker's trying to run this trial quicker, we still have a huge witness list for the state's case in chief. So if there's a possibility that Lil Rod's appeal could be successful and it could be overturned, not just for a retrial, but say something major happens and he's clear, he's let out, but then he's still stuck in custody because of this case here, it would make sense to file the motion for bond. And I think his attorneys will obviously have way better insight on that decision, and I'll wait to see if they move. I'll respect them for whatever they decide. And that's, yeah, he's got a bunch of attorneys. They seem to rotate in there. I know Angela Williams was the one that did the opening statements, and Leah Abbasi, I think, was there last week. But we'll have to see. Kimberly Griswold is saying it will be 5:32 p.m. when Love asks for more time to file. And then I saw you guys asking, I think YouTube, they do gift the memberships out sort of randomly, but one, you have to have it enabled. You have to enable the setting that allows you to receive gift memberships. You can do that by clicking the little money symbol where you type in the chat and then hit settings and then say that you're open to accepting gifts. And then it hands them out sort of randomly, but it is true that if you're active in the chat, you seem to be higher up on the priority list of getting one of those gifted memberships. So that's how that works in general. And then hey to everyone, because I didn't really get to say hey, we got right into the documents. So I have so many. If I were to go back to the beginning, I know it's going to be like hi, 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 hi. So sorry about that, but you know, got right into it. And then I am looking to see what else Steele might file, because just because we got 3 motions from Steele last week doesn't necessarily mean anything. We might get more. We might get more. Okay, nothing new either from Thugger Daily or Joseph Papp. So we might have an evening flood, you guys. What do you guys think? Because if Doug Weinstein had these done pretty much on time, because he was already saying last week that he was working on stuff, that they were working on stuff. If everyone else is going to flood these in at 5 o'clock, we might have like 2, 3, 4 hours of stuff to talk about tonight. So should we break this live stream and come back when new stuff is filed? Do it in 2 parts and keep these live streams just about the filings? Because I guarantee you we're going to get some stuff that comes in at 5 p.m. no matter which side it's from. Oh yeah, wasn't he so on civil law? Was he making shrimp and grits? Right? It made me hungry. I saw that when I opened YouTube. And then, so Kayla Bumpus, her YouTube channel, guys. Someone that knows her, or it came through her assistant. So she had her assistant have access to the account to help her manage it. And someone got access through the assistant's access and started deleting all of Kayla's videos. So she tried to change her password and re-upload everything, but they still had access through one of the Google accounts through the assistant. So they did it again. So Kayla Bumpus was on the phone with someone helping her out for like the whole weekend, it seems like. So she's actually in control of the account now. The handle itself looks different. It's like BUJ. It's like some letters and numbers. But that is her. She told me that's her. She confirmed to me because I also asked. But she's like, I still just haven't re-uploaded everything so far. So just so you know, that is her real channel. There was an issue because someone had access, and it seems to be someone that knows her in some capacity because they were talking to her about her kids through a message, through a YouTube description. Like, really just some grimy stuff going on. And I hope she can kind of work backwards to try to figure out who it might be. Because that's not really... It's not a good thing to do. It's not a fun position to be in. And it's kind of scary when people are coming at you with personal details about yourself, looking at your life, and ha ha ha, I have your account access. Really not good stuff. But currently that account, it's hers, it's owned, and it's her that has full control over it again. So if you guys are wondering what happened to Kayla Bumpus's content, she says she's planning to re-upload it, but she's just, she wasn't bothered. She didn't want to be bothered to re-upload it all right now. And then let's see. And then, yeah, so I think it's early. So why don't we do that, you guys? Why don't we... I mean, if nothing else, by 5, I'm sure we'll have at least one filing. I can pop live again, and we can go through it. If something comes through earlier, I can pop back on, because things should keep filing in around 5. I'd be really shocked if we don't get a bunch of filings. And I guess I wouldn't be shocked if the state filed it after 5 p.m., but they'd be really stupid to file a day late with Judge Whitaker, with a new judge, to already be pissing off a new judge. I'm not saying I have faith or confidence that they'll get it in at 5 p.m. today, but it might come through at like 5:30, 5:42. And we could start a live maybe around 4:30 or 5 to start going through the second set of things that come in today. Because otherwise you guys are going to be here all day while we wait. And I do think that these are it for Weinstein, because he had specified he was doing a motion for bond and a motion for mistrial. And since this motion for mistrial kind of combined the state and the judge working together, the judge violated the rule, but the state asked them to. I think that it's just one motion for mistrial on all of those grounds together. So let's do that. Let's do that. And then, yeah, you're right. They're going to flood at 5 p.m. Oh, Drea. Drea, always take care of yourself. Everyone, show Drea some love in the chat. Ooh, and yeah, don't put me down a rabbit hole. Guys, that Sonia Massey shooting is crazy. I'm not surprised that guy got charged, because I think they realize how bad it would be if they didn't charge. And it's not just because the shooting itself, it's because that same officer, guys, this is the woman who around 4th of July weekend, she'd called the cops because she heard someone outside of her property, and then while in the house, she was initially sitting down with the police officers. She went to go turn off boiling water, and the cop suddenly thought, while he had his body cam off, there were 2 police officers. The one who did the shooting had his body cam off until after the shooting, and the other cop, he was like kind of he was like peeking into the garage, and the woman was like, why are you going all the way over there? And the second officer laughed and says, because I don't want you to get any hot water, boiling water on me. The woman says, I'll rebuke you in the name of Jesus. And they're separated by a kitchen island, like a kitchen counter. And the first officer standing closer to her, but across from the island, just wails off. And then when she's down, the second officer says he's going to go to the car and get the medical kit, the first aid kit. And the officer that did the shooting said, don't bother, there's no point, that was a headshot. So the second officer ends up going to get the medical kit anyway, and the woman's still gasping on the ground. But it's really not a good look if your officer fires off and shoots at somebody that quickly, and then also tells someone, don't go get the thing that you need to possibly render aid and save this person we just shot. So the department absolutely had no choice but to charge. I'm I can say I'm surprised because we hear all these circumstances where officers, this happens and they're put on suspension or paid leave, administrative leave. But I do think that this one's a little bit different. So I'm not that surprised that in this one particular instance, they charged that cop. And they only charged that cop, as far as I'm aware, with straight up murder, first-degree murder, not, reckless manslaughter or anything like that. But it turns out he's moved 6 different departments. This was his 6th department in 4 years. Like, just crazy stuff. So let's wrap this up. Sorry to put this on a bad note. Sad note there. That is a really rough, and the body cam footage is on. The police department uploaded it. It's blurred, so you don't really see the body, but you still know what's going on. So that's out there. Really sad to watch. Really sad to think about. And I'm sure we'll hear more about that case as it goes on. But let's do this. You'll see, put the notification bell on. So that way you get a notification when I go live. And we'll come back around sometime between 4:30 and 5 when these motions should be coming in for the deadline. You guys all take care. You guys all have a good one. Thanks so much.